Vulnerability is a state that can affect any of us at any point in our lives. It could be permanent or temporary. Permanent perhaps because we have a physical or mental illness, or temporary because we are affected by something that's happened in our life, such as a bereavement or a relationship breakdown or any other stressful life event.
Vulnerability can have a wide range of causes, some of which may not be immediately obvious. It can be caused by medical conditions like dementia or personality disorder, or by things like social isolation or grief. It can also have physical causes like mobility problems, for example. It's often age-related, so conditions like dementia will most often be found in older clients. As legal advisors, we need to recognize the circumstances that can make clients vulnerable and to tailor our advice to each individual client.
In terms of telling whether a client is vulnerable, we need to understand the particular circumstances and the external factors that might be affecting them. These might range from being obvious and diagnosable to invisible or even fluctuating. When we are dealing with a vulnerable client, we need to give the necessary care and attention to understand their overall personal and financial circumstances, the factors that may be affecting their decision-making, and where the areas of risk are.
So most of us can take steps to protect against future vulnerability. That can involve putting in place things like a will or lasting power of attorney, or by setting up a trust either for ourselves or for someone else who we think may become vulnerable in the future. Even where someone does suffer from a condition like dementia, there's often still time for that person to put in place suitable planning. We encourage clients to think about appointing people who are really trustworthy and who they are confident will act in their best interests. That way, an individual can be confident that they have some control over their assets if they were to lose capacity. It's crucial to encourage vulnerable clients to communicate openly and clearly with us so that we can work out what they really want to achieve. That can mean removing them from the influence of a coercive family member, for example, or by making adjustments to make sure that they're most comfortable so that we see them at their best. If a client doesn't have the required level of capacity when they're making a will or lasting power of attorney, that document could be subject to challenge in the future. As legal advisors, when we're advising a vulnerable person, we make sure that we find out a client's real wishes and intentions, free from the influence of other people. It's often best to see a vulnerable person on their own, and that's a good way to make sure that they're not being influenced or coerced by other people.
It's not always obvious. The signs and states of vulnerability can fluctuate. Various vulnerabilities from addiction to dementia can change. It is therefore particularly important to be alive and flexible when advising clients and taking instructions. We need to be looking out for particular indicators such as coherency. As advisors, we really need to be alert to the signs of vulnerability, and this includes changing circumstances throughout a matter.
Invariably, an application to the Court of Protection will be time-consuming and expensive. It's far better to try and preempt the need to involve the court by putting in place adequate planning and safeguards ahead of time. In a worst-case scenario, where disputes escalate or financial abuse is occurring, it may be necessary to involve multiple agencies. So, for example, social services, the police, the Office of the Public Guardian, and then ultimately the Court of Protection. And this is where we can help you to navigate what might appear to be quite a complex and overwhelming process.